I'd like to tell you how social media can damage your personal injury case. Hi, I'm Richard Aufenger. I'm a trial attorney with the law firm of Kalfus Nachman, licensed in Virginia and North Carolina. Social media has really taken over the world, basically. It's new, dating back to about a little over 10 years ago when Facebook first started. But now you have Facebook, Instagram, Snapchat, Twitter, and it goes on. And most people use some form of social media. But when you have a personal injury case, you should not use your social media because things you post can damage your case, they can be construed against you, and the insurance company will pick up on it in a heartbeat. I see in many cases the insurance companies issuing subpoenas for the social media accounts, filing requests for production of documents. They get those social media accounts. And things that might have been innocently posted can be contorted and construed against you and really damage your case. I'll give you a couple of examples. I had one case recently where my client had a very severe and chronic back injury in an automobile crash. He hadn't recovered, and what he loved to do, though, was ride four-wheelers. And he had a number of them, and his family would go out and do it. He lived in the mountains. He couldn't ride his four-wheelers because of his back injury. But he had a photo op with his family, and he sat on one of the four-wheelers with his daughter, and a photograph was taken, and he posted it on Facebook. Well, of course, the insurance company gets it, and they're trying to say, see, he isn't injured. He's out there riding on his four-wheeler. So we had to explain it, and we did a good job doing it. I helped him with it, but it gave the defense something to argue. I had another case where my client was with his family, and they went up into the mountains to do hiking. And my client went with the family and took pictures, showing that they were getting ready to go into the Blue Ridge Parkway by the signage, and they were proud and a good, nice family photograph. Of course, the defense gets it, and they're saying, look, this man's able to hike. He couldn't have such a bad injury. He didn't go hiking. He sat there while his family went and hiked. He was there for support, and there when they went off hiking, and there when they got back. But taking that picture, again, gave the defense something to argue. I had another case recently where my client had already signed up for a half marathon, and she was a real athlete, had signed up for a half marathon before the crash. And about 8 months after the crash, she had already signed up, couldn't get her money back, and a bunch of her friends were running, so she went there to the half marathon in the morning, and it was hot out. She was dressed in running gear and had a picture of her taken with her friends. She didn't run the race, her friends did. She was there for support, but she posted that photograph on Facebook. The defense got it, and they tried to argue that she ran the race. So, you've seen just a few examples. It's best not to post and use your social media while you have an ongoing personal injury claim because it can be used against you. But be warned, if you already have a case and you've already posted something on social media, don't go back and delete it and try to put it in the trash can or get rid of it because that can be used against you. If you've been injured in a motor vehicle crash or other type of injury because of the negligence of someone else and need advice about social media or just about your case in general, give me a call. I'm happy to answer questions and certainly would like to help you.